Hey guys, it's Brad from GeorgiaProbateResource.com. So today's question is, does a spouse need to file for probate? Again, guys, I'm Brad from GeorgiaProbateResource.com. We're a real estate solutions company in Metro Atlanta, and we specialize in the world of probate and inheritance properties. So today, again, we're going to talk about, does a spouse need to file for probate? And the answer is maybe. First of all, were you on title to the property or were you not on title to the property? If you were on title to the property with your spouse, you need to review your deed and determine whether you were joint tenants with the rights to survivorship or joint tenants with survivorship. Sometimes it's said both different ways on the deed. What that means is that there are two people that own a 50-50 ownership of a property. When one of those people passes, the surviving person now obtains 100% ownership of the property, and in which case probate would not be required for the purposes of selling the house. Now, you still may have to do probate for other assets within the estate, but for the purposes of selling the house, if you are joint tenants with survivorship, then the surviving spouse now obtains 100% ownership upon the death of the other spouse or the other person on title. It doesn't necessarily have to be a spouse. If there are two people on title, the surviving person would obtain 100% ownership. Now, if you are tenants in common, and the way to distinguish the two is that if you go back and you look at your deed that was prepared for the property, if you are joint tenants with survivorship, it will explicitly say that on the deed. So the deed will say, so-and-so and so-and-so as joint tenants with right to survivorship, or joint tenants with survivorship is what it will explicitly say in the deed, in the verbiage of the deed. If your deed does not say that explicitly, then more than likely you are tenants in common, and in which case, upon the death of the spouse, the deceased spouse, their estate still owns 50% ownership of the property, and the surviving spouse on title also has 50% ownership of the property. So you need to make sure that you read that language in your deed, because it's going to tell you if you are tenants in common, which is the second scenario I just talked about, where it doesn't explicitly say that there are rights to survivorship, then in order to sell that property, you are going to have to file for probate on the other estate in order to be able to say that, because someone, a representative of the estate, whether that's you, in most cases is typically the spouse, but not in every case, that person is going to have to sign on behalf of the estate in order to convey that 50% ownership of the property. We get this question sometimes, which is, what if I'm just going to stay in the property? Do I need to file for probate? And I can't tell you how many scenarios we've run into where, a husband and wife owned a house and the husband passed away and the wife just stayed in the house, but the wife was not on title to the property. And they stayed living in the house. They kept paying the property taxes, kept paying the mortgage, all that sort of thing. And then one day in the future, that spouse decides to sell that property. And now all of a sudden, they're like, oh, we have to file for probate. So they end up realizing that they have to file for probate in order to sell the house. And I can't tell you how many other times we've dealt with a scenario where that same thing happened, and then both people die, and then one of the kids moves into the house, and then they don't file for probate, and then they die. We literally had this scenario on a property very recently where we got a phone call from someone who essentially their grandparents had owned this property, never did probate. That person we spoke to, their mom moved into the property to care for her dying mother. And then ultimately, so the grandmother died, and then her mom died, and then she moved into the property and has lived there for a number of years. And then now all of a sudden she wants to sell the property, and she can't because she's got to actually file for two different probates in this situation. And unfortunately, in her case, she couldn't keep up with the property taxes, and ultimately the property taxes got delinquent, and the house was sold at a tax lien auction. Now, she does have, there is a 12-month right to redemption period here in Georgia. So if your house is sold at a tax lien auction, You as the owner, the person who didn't pay your taxes, you still have 12 months to redeem that property, but now you've got to pay back the amount it sold for at auction plus 20% in order to redeem that property. Now you are entitled to overages in the event that, let's say, you owed $15,000 in taxes and it sold at auction for $60,000 to an investor. You are entitled to the excess funds, is what it's called, but you have to go through a process to get that. And you also have to pay the full amount, and then they refund you back the difference later. So you're going to have to come up with a difference. And in this particular scenario, this lady that we dealt with, unfortunately, the property was in pretty disrepair and it needed a lot of work. And the price it ultimately sold at auction for, plus the 20% and all that, it was actually, it was not what we were wanting to offer. It was more than what we were willing to offer on the property. So the numbers to us just didn't make sense. And in our opinion, in that scenario, like in her case, she's better off just letting it go to the tax auction. Now, it was going to be difficult for her to go get those excess funds back from the state because those funds technically belong to the estate, not to her. So she would still have to go probate the estates in order to get those excess funds back. But from our scenario, in terms of buying the house, it just didn't make financial sense for me to purchase this house from her because the person at tax auction paid more money than I was willing to offer on the house. So ultimately, more than likely what's going to happen is this person that bought it at tax auction is ultimately, after they wait the 12 months plus they go through the embarment period, which is essentially like a quiet title on the property, it's going to take them another 6 months. So in 18 months, they'll be able to get clear title to the property and own it. But unfortunately for her, this property that's been in her family for many, many generations is now going to be lost because they didn't file for probate. Also, one of the things she told us was like, well, we can't afford probate. And the reality is that, you know, she'd seen some of our resources that we have here. You actually wouldn't have had to file for, or well, you wouldn't have had to pay everything up front for probate because there's a lot of attorneys out there that will actually sort of front the cost up front and then you reimburse them later after you sell the property. Depends on the attorney. Not all attorneys do this, but had she seen some of our other content, she would have realized that. Should the surviving spouse need to sell or need to do property, and especially if you're going to stay in the property, I would consult a probate attorney, but it would be in your best interest to go ahead and do that now and knock it out and get it over with. Because if you wait, what happens if you pass away and then now your kids or your heirs are left with this mess that's got to be cleaned up later? And the longer this goes out over time, the messier and the messier it gets, to the point where, you know, the probate could be a mess, and the messier this probate gets, the more expensive it's going to be. So you might get to the point where, you know, you're leaving your heirs having to pay, you know, $7,000 to probate this estate because it's gotten so messy and so complicated. So that's my answer to the question. I know it's a little bit of a long-winded answer, but that is a scenario that we've encountered recently. So I hope that answers your question. Again, I'm Brad with GeorgiaProbateResource.com. We're a real estate solutions company in Metro Atlanta, but we buy houses all over Georgia. We specialize in the world of probate and inheritance properties. And if you want to sell the house to an investor like us, get a quick, easy, fast cash offer. You don't want to mess with it. You just want it done. You want to move on with your life. We can make you an offer on that. Or if you want to go the traditional route, you want to list it with an agent, you want to get top dollar for that property, you have a really nice property, you want to put it out on the market, try it out there, go through that. I'd love to chat with you about that because I'm actually also a licensed agent with One Source in Woodstock, so I can help you list the property as well. So thanks again for your time. I hope that answered your question, and I hope you have a nice day. Bye-bye.